Corey. Thank you to the previous speakers. Let me just get my screen set up running and we can get going. Hopefully you can see my my screen now. I'm going to talk today about trade secrets and corresponding rules in Southeast Asia. Before I do that, I want to talk a little bit about the SME help desk in Southeast Asia. There we go. The Southeast Asia IPSME Help Desk is a European Commission initiative which provides confidential business-focused advice to small and medium-sized enterprises in the European Union and other countries of the Single Market Programme, so Norway, Iceland, Liechtenstein, Ukraine, etc., all relating to intellectual property rights. On this slide, you can see the range of services offered by the Help Desk. There's an inquiry helpline. You can send IP questions to that. There's monthly training workshops. There's live webinars, the website. There are a whole range of publications, all of which can help guide SMEs across Europe and Southeast Asia on various IP topics. There's a whole range of different ones. And just for the purposes of this today, next slide, there we go. This is a snapshot of our trade secrets guide. So you can look at that if you want to access more information on trade secrets in Southeast Asia. Lastly, there's also a one-to-one consultation service where you can actually contact the SME Help Desk and have a one-to-one discussion with the project's business advisor who can give you practical advice and recommended steps on how to proceed. So you can click on the link and book such an appointment, and they'll be able to help you set up that. So I have the slight disadvantage of going second, and what you're going to hear today is some very similar things to what you heard earlier on in Europe. There are some differences in the laws, and there are also some similarities. So you might see some common language, which hopefully will help you understand the issues, but you might also see some differences. I'm going to talk about some definitions, the different legal systems in Southeast Asia, some case studies, and some practical tips. So the three common elements that are used to define trade secrets. Well, not publicly known. We've already talked a little bit about this. The data must be something that's not generally known to the public, not ascertainable by the public or by competitors easily. It's got to have economic value, some kind of advantage, cost advantage, or other economic advantage to make a higher quality product or some other value-related aspect. And you must have taken steps or made efforts to keep this secret. So using non-disclosure agreements, for example, you've heard already. We'll talk in a bit more detail, and you can see the little diagram on the top right. Just remember those three things. It's got to have value, be secret, and you've got to put effort into keeping them. They're different from other forms of IP. Patents is the most commonly associated or neighboring right to trade secrets because they're both commonly used, but not exclusively used to cover technology. The difference is patents are granted and published by governments. And that publication is what makes it different. Essentially, the patent system enables a bargain between the state and the inventor that you get an exclusive right to the invention for a limited time, usually 20 years. But in exchange for that, you've got to publish it. Now, trade secrets are not publicly known, and they can last much, much longer. So for certain types of things, they have incredible long-term value. WIPO, World Intellectual Property Organization, has some definitions as well. This is a slightly different set of wording, but broadly the same thing. Some of the types of things that count as trade secrets, of course, highly technical issues, but also some quite mundane ones can be trade secrets, such as sales and distribution methods, customer profiles, your pricing strategy, advertising, marketing plans, new brand names are kept incredibly secret. Lists of suppliers and clients, of course, all the technical things from manufacturing to R&D to recipes, raw materials, product designs. It's incredibly important to keep product designs secret. Data and algorithms today are absolutely critical to big tech companies. How to use technical equipment, all kinds of financial information, general business information, employee remuneration, business projections, and many more things. I give such a broad definition to show you that pretty much everything can be a trade secret if it's so protected. So who uses trade secrets? Well, frankly, every business in the world. Technology companies use trade secrets to protect their data and algorithms. Manufacturers keep their manufacturing processes secret. Suppliers and subcontractors, same thing. Even sales and distribution companies, franchise businesses keep their franchise processes secret. Designers, product designers, startups, it's absolutely critical for startups. And the famous situation for startups is you've got a venture, sorry, an entrepreneur who's got a great idea for a business. He rushes off to tell everyone to raise money and gives away his trade secrets before he's actually raised any money. So there are ways to stop that, but that's a critical one. Pretty much everyone today has trade secrets, most businesses. So some of the legal aspects. IP rules basically are national. In trade secrets, there are no sort of higher level supranational systems. There is country by country protection. You heard earlier on that the WTO has these TRIPS rules which protect undisclosed information. Now that can cover a variety of different things. It was a deliberately broad definition to encompass a multitude of things. Not quite the same in every country, though. There are other treaties that apply in Southeast Asia. So the RCEP agreement, which has currently been signed by ASEAN and is being implemented slowly. That follows the TRIPS definition of undisclosed information. The CCPPP, which is an agreement, Trans-Pacific Partnership was the previous name. I think Singapore and Vietnam are both members of that one. That has some additional requirements in criminal liability, which is not always required in other countries. The key difference, however, is the fact that within Southeast Asia, we've got civil law and common law countries. So those two fundamental differences create slightly different regimes. And typically, common law countries call this confidential information, which is possibly broader than just trade secrets. And there are some unique differences with confidential information. It doesn't create property rights. And most of the law is found in court decisions rather than in statute. Civil law countries use typically the trade secret terminology. This is a form of intellectual property right. It's statute based, much more specific. It's also assignable, a form of property. That actually makes it slightly easier to attribute commercial value to it. And it requires some level of active protection as well. So there are some slightly subtle differences you can see between civil and common law. The laws are not harmonized yet in ASEAN. I'll be at a meeting next week with ASEAN member state IP offices, and that's one of the topics we'll be discussing is the potential harmonization and upgrading of particular countries' regimes. So just remember that in different countries, there are slightly different rules and they may have different consequences. I mentioned patents and trade secrets. The big rule with patents is, and the same with designs, is when you are at the pre-filing stage, before you filed your patent, the principle is disclosures, invention disclosures, design drafts must be kept confidential. If you don't do that, you could lose the patent or the design later. Basically, you've got trade secret protection before you file the patent or the design. That's the way to think about it. And as I mentioned, there's no time limit on trade secret protection. So if you're building a long-term product, that's extremely valuable. And I have had companies that I've worked with, even some who've gone through incredible success and listing on stock markets and so on, where trade secrets was chosen as the avenue to protect the technology instead of patents. It certainly can be, not always, as you'll see from this talk, can be cheaper to secure than patent protection. So this slide, I won't stop on here. This is just to set out, this just sets out all the laws of the different countries. We can share this afterwards so that anyone who needs to can have access to that and actually look at the laws. This slide helps to kind of see where trade secrets sit in a sort of hierarchy of laws. It's a bit rough, but patents, designs, copyrights, other forms of technical IP can protect all kinds of technology in different ways. Patents and designs are registered rights. So that gives you this sort of ability to actually go and get a document which identifies very clearly what your right is. Even copyright. Now, copyright typically covers written documents, and many, many written documents include trade secrets. So there's often a huge overlap with copyrights in trade secrets. You take a franchise manual, for example, for a franchise company. That if that is a secret document, if the company's kept it trade secret because it has unique processes for running the franchise, there are trade secrets in there, and the manual is protected by copyright. So there's all kinds of ways that other rights connect with trade secrets. And the difference with registrable and non-registrable IP, well, I've mentioned the fact that one is clearly identifiable. One of the challenges we'll talk about in a moment is the fact that unregistered rights, like copyrights, like trade secrets and other unregistered rights, are unspecific often. They're collected in the databases and the IT systems of companies. They're not always collated, analyzed, organized, protected through IT technology and so on, which we'll talk about. So one of the challenges is how do you manage your unregistered rights? You don't have a registration number and a document from an IP office to tell you what you own. You've got to go and organize that yourself. Know-how and the interaction with know-how and trade secrets comes up a lot. Know-how is kind of a broader definition of business practices. This is not a legal term specifically. It does get used frequently in contracts. It's often thrown in by lawyers to refer to something that's maybe not as specific or not as high level as a trade secret, maybe something that is a bit known, but it's certainly a valuable asset in a business. It's the way you operate that maybe not so secret, but certainly is your part of your secret sauce and your business success. So think about that as a sort of lower level, but something else you need to think about. In the 21st century, digital technology companies, I would say for many of them, trade secrets are more valuable and more important than patents for some of the world's big technology companies. Yeah, it's sometimes said that data is the new patent. So yeah, data is something which we'll talk about. It's something in the 21st century which you can protect positively as a trade secret, but it is also negatively protected. That is, there are rules against how you can use data and particularly personal data. So that's something just to keep in the back of your mind. If you're a data-driven business, trade secrets are incredibly important and incredibly important to deal with the interaction with data privacy laws. We're going to talk about some of the ways to protect trade secrets now. You've heard already, you've got to keep them secret. The clue is in the name. It's got to be kept secret. I'll say that over and over again. My previous speakers said the same thing. Can't underestimate that enough. If you leak your own trade secret, you go and present it at a conference, pitch it to investors, whatever, there's nothing you can do to help yourself at that point. We'll talk about how to stop that in a minute. There are three broad buckets or techniques of processes to put in place, and I've categorized them as legal, physical, and technical. And we'll talk through those in some detail now. It requires work. I said trade secrets can be cheaper than patents. Well, not if you haven't got any processes in place. You will have to put some business processes in place. It will cost you some time, effort, and money to get that right. There are both internal resources, lawyers, HR, IT, management, corporate security, many other different people you will need in your corporation to help you do this. And you will require external advisors, lawyers, IT consultants, and other consultants to get this ready. So let's do a deep dive now into these three stages, these three different techniques or buckets of processes. So let's start with physical. I've listed lots and lots of different things here. It's not exhaustive, but to give you a level of flavor of the level of detail, locks on your property, physical security, security guards, contracts like NDAs, physically signed, collected, and held, although I accept that can be done digitally these days, so I'll cover that the second time. Putting in place access rules, having different location and premises rules and systems in place. You know, what access to sort of design areas might be different from access to your reception. I frequently go to visit my clients and I go into locked, secure areas to look at new technology. Visitor restrictions, visitor logs, staff sign in, key cards, documents physically marked confidential with a stamp. Basically, a need to know approach taken by companies. Now, that might sound scary and sort of cloak and dagger. It is routine in technology companies. It is routine in companies that have high levels of security. Now, in Southeast Asia, many businesses remain quite open and not necessarily used to such things. Unfortunately, this is the way you protect trade secrets, and you have to put this in place. How do you do it? You've got to have the internal management first and foremost on side. The management, the board have got to agree to do this. This is protecting the most valuable assets in the company potentially. So it shouldn't be a difficult process to convince them of this, but don't just hand it off to a manager, HR, legal on their own. It needs to have management support. You will need HR involved in a lot of this. You will need your security, your premises, your facilities teams, and other administrative management to help execute all of this. When we go into companies and help them do this, we would have a whole day workshop with administration and security and so on to go and pull this together. Let's now look at the technical side. This is principally IT related, but not exclusively. So let's talk about some of the IT things. I wouldn't dream to pretend to be an expert in this. You bring an IT consultant in to help figure this stuff out. You have device restrictions. You know, even my phone is restricted on what I can do in terms of accessing my corporate network. Copying restrictions. You can't copy and paste things. You can't copy documents. Using password rules, using encryption. Obviously, cybersecurity to protect your whole network, but also data partitions, particularly using cloud storage. You've got to be careful. Drive limitations. Putting in place ISOs and IT policies. There's lots of different policies that need to be put in place. HR need to work with you on this. They need to teach people what these policies mean. You can't just have a click and accept and no one's actually read it. You use your staff manual to underline this. Staff that join you get given trade secrets training. Exit briefings when staff leave to underline how important it is they do not share trade secrets and keep a log of all of that. Regular staff training. Confidentiality notices can be automated using pop-ups. Obviously, data logs and reports can keep all access reports and so on. And ISO 27001 is one of the ISOs that you can use to help implement a lot of this. As I said, your internal team will be involved, but IT consultants come in to do this kind of stuff. You know, we hired a company to come in and do our ISO work. Your HR team will need to be involved. The legal department has to work with the HR team to review the policies and manuals and make sure they're all, you know, up to scratch. You know, that's just a flavor of some of the technology and technical issues you need to think about. And then on the legal side, okay, we've mentioned contracts, NDAs. Very important to get this right. Lots of contracts will have to have confidentiality clauses in there. All the sort of external ones, your business partner, your sourcing, joint ventures, subcontractors, suppliers, all of your staff contracts, employees, officers like board members, non-disclosure agreements. You sign those with people you are about to have a conversation with before you've disclosed anything. Anyone who says, "Oh, I don't believe that. I do my business on a handshake," not true. That is someone who's trying to con you. Don't do business with someone like that. In Southeast Asia, it is routine now to use NDAs and all kinds of other contracts. Just one little, a couple of little details here. Be careful. Some contracts might require you to record certain types of trade secret agreements, licenses, for example. So just keep note of that. Don't file the license without thinking about whether you're disclosing it. Sometimes you can use different formats of that. And I mentioned startups. I want just to cover a bit on that. Startups, very common that an entrepreneur starts a business. He hasn't got his legal entity set up. He goes out to get his venture funding. You've got to figure out how to get the trade secrets into the business if there's any pre-incorporation trading. That is, the company is not yet set up, but the entrepreneur has already started work on the trade secrets. So figuring out how to get those into the corporate entity is quite important. The venture capitalists will need to know that before they give you any money. They will pay for it, by the way. I've had great deal of experience going to VCs and saying, we need to get the trade secrets aligned and in order and get some contracts in place because they want to protect their assets or the company's assets when they're investing there. So a bit of work on startups is always worth, with talking to lawyers before you get going is always worth thinking about. Legal training for key management staff. This is important. And unlike other types of law, this is an area they do need to understand a bit. They need to understand what keeping it secret means, making reasonable efforts, what is information that has value, how they can identify a trade secret. They can't call the legal department every time they think of something related to trade secrets. They need to have some basic training. I wanted just to mention one more thing, non-compete agreements. This is something which is commonly used for senior employees when they leave. They are not always valid. They get overturned sometimes. So don't put all your trade secret clauses in your non-compete agreements. You might have to have two separate agreements in case one falls down or fails later. So as you can see, you're going to need potentially an in-house legal team if you're big enough. If not, external lawyers, sometimes both, and you'll need your management team involved. That's a very big rush through of what would probably be 3 or 4 days of workshops that we would run for a large corporation to sort of sort out their trade secrets. That's the kind of thing we go through. Certainly in Southeast Asia, we've done that at investor phases, when private equity comes in, when you go through any kind of financial event, and of course, when companies want to develop their trade secrets and protect them across the board, especially after M&A. This is really common when companies either merge or they're separating. The trade secrets must be sorted out. They are frequently forgotten as part of the due diligence exercise. So some of the issues around managing trade secrets. The challenge of definition is one, articulating them clearly, trying to set them out and explain what they are is often quite difficult. Essentially, you've got to write them down in a document or capture them somehow. Obviously, where you've got labs and highly sophisticated R&D, you'll have technicians producing lab reports and data sheets and all of that kind of stuff. That's very straightforward. But in much more broader technology businesses, when you've got algorithms, when you've got manufacturing processes, it might not be that simple. And so there might be a long, boring process of sitting someone down and getting them to write out the trade secrets. The next thing is to ask whether you should audit them and capture them. In an ideal world, you would, but companies can't always spend large amounts of money just simply organizing their internal intangible assets. Many don't do a very good job at this, and litigators, some of my colleagues earlier on, will know that there's often a panic at the stage of litigation to try and figure out who's got the trade secrets, where are they, who owns them, who created them, when, and actually getting some documentation in place. In an ideal world, you do that as you grow. Particularly small businesses have the advantage of being able to do that. Write it down, keep it secret, and you're going to be away. Trade secrets databases do exist. There's a couple, Hazel, Tangibly. There's various other ones that that we've worked with, and they do exist, but they're not. I mean, for big corporations, they're a vast amount of work because a multinational is going to have 100,000 trade secrets, no problem. How on earth do you document something like that? So if you're a mid-sized, small company, or you're growing and you want to get in early and get this right, not expensive to license one of these databases and start capturing or say trade secrets as you grow. I have to say, when I first started in IP, trade secrets were not a very high profile, very important IP. I would say that the amount of attention paid in trips to them is low because the amount of attention being paid to trade secrets in 1994 when trips was 1995. Oh yeah, 1994-5 when trips was implemented was not that high. And so, yeah, nowadays it is vastly more important. It has been made more important by the number of high-profile trade secret theft cases, also by the fact that the digital world and the creative world and many other worlds have now suddenly discovered that they are immensely more valuable when they protect their trade secrets. Cross-border trade secret management is complicated. If you transfer data outside your country, even through a cloud server, you must make sure you get that right. You can't just say, oh, I'll just throw my data up into the cloud and it's fine. You have now moved it into a new jurisdiction. Be very careful with that. There are contractual requirements. If you're using a good server IT provider, they'll hopefully give you good contracts, but your lawyer must look over those. And what happens if there's a data leak? You're going to lose all your trade secrets. What insurance have they got? How are you going to be protected from that? I've listed some of the risk areas there: inadvertent disclosure, employee theft, competitor theft, cyber attack. Those are the bigger ones. And then in certain sectors, industrial espionage. These are where you need to pay attention. I've got a number of case studies here. I'm not sure how much time I've got, Corey, to keep going on this, but do shout if you need me to wrap up faster.
You can continue, Nick.
Great. There are not vast numbers of trade secret cases in Southeast Asia. There are some, and they've been around for some years, but probably you get one case every few years in a Southeast Asian country. So this one, for example, in 2005, very straightforward. Classic example: staff dismissal for disclosure of confidential information. In this case, an employee sent to her sister telling her about the company's products. The Ho Chi Minh City People's Court decided that one. The dismissal was correct, and the court considered this was properly done and the contracts were valid. This was straightforward trade secret theft. Just to show you that you can protect trade secrets in courts in Southeast Asia, even in less developed countries like Vietnam, which actually does have a civil court system which can work effectively. Singapore, you might expect this to be much more sophisticated. There are lots of cases in Singapore. It's a common law country, so it's different structure. In this case, two former employees set up their own company providing competing services. Another extremely common scenario. In this case, there was an Anton Pillar order. For those of you that understand common law, you'll know all about those. Civil search and seizure orders, seizing laptops, discovering documents. However, in this case, the court went through a deep analysis and found there was no breach of confidence, which is the law of Singapore. Just because the documents were on their laptops didn't prove that they had actually used them in their competing business. So there's a sort of beware point there. Just because someone has seen them doesn't mean they've used them. So you can't stop people having and continuing to hold the knowledge in their head, or even in this case, documents might appear on a laptop, possibly forgotten. But the point is about trade secret, it has to be misused later on. A couple of cases from Malaysia, old and new. Again, Malaysia is a common law country, so we're talking about breach of confidence, misuse of disclosure of trade secrets, breach of terms of employment, and this analysed the confidentiality clause in the employment contract in some detail, and it imposed an obligation of faithfulness, and therefore an obligation to keep the confidential information secret. That was during employment. In a post-termination situation, in a different case, the question was, how long does this confidentiality clause exist? And in this case, they held that it can exist long after the terms of employment have ended. And this goes to my point about using exit interviews, briefing your employees, making sure terms of contract employment survive after the employment contract terminates, or whichever contract you're talking about. Post-termination, continuation of trade secret protection is vital. I did have another case from Indonesia, but it was incredibly complicated. There has been one in Indonesia. I decided not to go down that route because it was very connected with a whole series of design rights cases as well. So I thought I won't put that one in. But just to show you that all across Southeast Asia, the courts are familiar with trade secret cases. So don't think you can't get some sort of recompense. But of course, I would say be careful. Courts are maybe not always as well developed as other countries. The damages awards might not be as high as you might hope. You've got to prove some form of losses. There are all kinds of litigation challenges, which I won't go into today. Lastly, last slide, some tips. I've talked about trade secret protection as a legal issue and also a business issue. I want to underline that. This is not just for lawyers. This is for the business guys to get as well. It starts with management commitment and business processes. Frankly, you need lawyers to come in at the beginning to help you figure that out. But sometimes you bring a lawyer in to say, do this, and then the management team have got to get on with it for quite a long time before the lawyer needs to get back involved. Many other departments within a corporation, many other people are involved, external and internal lawyers, contracts. If you don't have a contract, there might be some implicit or fiduciary duties that exist that can help you. Directors often have an obligation. They don't have a contract of employment, sort of a director's contract, but let's not rely on hoping the law is going to help you. Prevention is better than cure, because there is no cure when you give up your trade secrets. Unfortunately, if it's no longer secret, you've lost it, it's gone, and you can't stop it. So this is one where prevention is absolutely critical.